Hi, my name is Chuck Schmall, and I'm a patent attorney at the law firm of Woodard, Emhart, Moriarty, McNett, and Henry. This presentation is an excerpt from a longer live presentation about the America Invents Act, commonly known as the AIA. This particular section generally concerns power of attorney procedures and practices for U.S. patent applications. In particular, we will discuss the timing and procedures for filing powers of attorney under the new AIA rules. Additionally, we will discuss how to fill out the PTO AIA 80 and 82 power of attorney forms. This presentation is provided solely for educational purposes. Hopefully, it will provide you some practical guidance on how to navigate through the new procedures and rules under the AIA. However, since these rules are still rather new, we had to make some educated guesses as to how the United States Patent and Trademark Office will implement them. So there is a possibility that the Patent Office will interpret them differently than presented. If you have a specific question about this topic or any other patent-related topics, please consult with an experienced patent attorney or agent.
Okay, this is my favorite topic to talk about, power of attorney practice. And they've made it complicated again. So we're going to walk through this. As you'll notice, I have a couple of things here, gave you packets. The 3-hole punch, thanks to Lori. I have a checklist, or checklist, as you like to make fun of me for. It's fine. You make fun of me. Filing applications, I always use this so I don't mess up stuff, and even when I use it, I still mess up stuff. I've added new sections on here. For example, we're going to talk about AIA statements later on, and some things about foreign priority documents. It's going to be in here. That's one thing. I have a sample new version, at least the latest and greatest as far as we know, but they're constantly changing them with the AIA. New ADS. If you want to spend time going over it, I think you all pretty much know how to fill them out. But if you have any questions, just holler up now, or we can talk later. And then I have some samples and other information about powers of attorney. And so you might want to just pull those out right now. Oh, I also have a provisional cover sheet showing you that. I mean, that's really nothing new there. There's power of attorney documents, and we're going to go over that in a second here. Okay, let's talk about why we file powers of attorney. A couple of reasons. One, this is the most important reason, and this is why you have to do it, is the power of attorney gives us access to the application before the application publishes, or will give us access if it's an unpublished application, if we select it to be unpublished, so that we can do our status checks. You guys don't do it anymore. Docketing does this, I think, still, right, Mark? Every 5 months, and we chose not 6 months, but the PTO has a default rule. If you do a status check every 6 months, you're safe, okay, because you're checking on the status of the application. If we don't file the power of attorney, what's going to happen is it disappears off our radar. We cannot see it on PAIR. We cannot access it because they're pretty quick now. A couple of days, if you don't have a power of attorney in there, we can't access it on PAIR. All right? So that is vitally important so we can run our routine status checks. So if the application does come abandoned, we can submit a declaration and say, hey, we were diligent. Here's our evidence of our checks. Because if we can't check it, then we're toast, and it's going to be a significant malpractice issue. So that's the most important. That's the main reason why we do it. All right, it's just not because we like doing, creating extra work again. There's a minor thing about helping out attorneys with interviews. Technically, if I don't have a power of attorney, as a patent attorney, I can do two things. I can sign stuff and represent as a representative authority, where I don't need a power of attorney. I can just sign it because I am an attorney, and I'm not going to go out there and just sign stuff for competitors out there and just file stuff on the weekend for IBM or Microsoft or something like that. So I could just say, hey, I have the authority to do it, and I can just sign off on it without a power of attorney. However, when it comes to interviews, technically speaking, if you go conduct an interview with an examiner and you do not have power of attorney, they get squirrely about it, and more importantly, they will only look at stuff you submit. So they are technically supposed to close the file when you do an interview with them, even though it might be public record. It's really weird. Anyway, helps out with interviews. Just remember that. And with terminal disclaimers, if I got to sign a terminal disclaimer as an attorney, I need power of attorney to sign a terminal disclaimer. Generally, that might be changing, but we'll see about that. So Again, under the new rules, you have the applicant. If you name them on the ADS, they will be the applicant. So they will presume to be the owner. Some other things about power of attorney practice. What was formerly a 373B statement is now a 373C statement. Okay, now let's summarize. There are two ways to accomplish power of attorney practice. There's actually three ways, but the third way deals with inventors, and they have no attorney representing them. So there is a procedure where if you have like three inventors, they don't hire a patent attorney, they can give one of the other inventors, the authority to prosecute on their behalf. We're not going to talk about that because we're a patent law firm, and so I'm not going to confuse you anymore. There's two ways, and there's probably one recommended way, and we'll go with that. The one way is the old way, the general old way. There's some slight modifications. You file your general power of attorney form, and you file a 373C statement, which is an AIA 96 form. All right, and we'll go over that again. The other way is, I don't know why they did this, but they did it. You can submit this transmittal for power of attorney. They're trying to make it, I guess, similar to PCT practices for power of attorney now. We'll go on that more in depth in a second. And I have samples here. So first way to file, this is going to hopefully be just a general review, and it's in your stack. You have, I have also information in there about how to fill out the forms. This is PTO, it's on their website. So the first way, you file a general power of attorney. So you send that to the client, an SB80 form, have them sign it, and then you can have them, either have them sign the 373C statement, or the attorney, because that general power of attorney, if you look at the language, it says, a copy of this form, blah, blah, blah. The statement under 373 may be completed by one of the practitioners appointed on this form. So it gives us authority as patent attorneys, or patent practitioners, technically, to go ahead and sign the 373C form. So that's what the general power of attorney does. So you submit those two forms, fill out the real and frame number, and you're good to go. With this, you have to record the assignment at the same time. All right, and let's go do an example here. So again, you just file you have your general power of attorney form, and you file your SB96 or 373C statement, and you have to record the assignment. Now, technically, if you're filing with the application, you can attach a copy of the assignment with it, and just say it's attached here too, and then record the assignment. My practice is I just go ahead and record the assignment and then file the power of attorney form, just because it's less paperwork and you're going to have to do it anyway. So here's one example. What I normally do is file the application. Usually I'm not getting the assignments right away anyway at the time of filing. So when I get the assignment, I go ahead and record it. Actually, Laura goes ahead and records it, and then go ahead and we file a 373C statement naming the real and frame numbers for the recorded assignment, and then attach the power of attorney that was signed by the client, general power of attorney. Pretty straightforward, hopefully. Nothing really different here. You can also, I'm just showing you the alternative way here in this slide. You can file your general power of attorney form, your 373C statement, and you can attach a copy of the assignment if you don't want to record it, for example, when you're filing it with the application. You can do all that and establish power of attorney right away. All right. Normally, you don't have the assignment right away, and so you're doing this afterwards. But that's the other way of doing it. But the first way I kind of recommend better in example 1 more than example 2, because it's just less paperwork, less things you have to file and remember. Okay. This is the second way, and this makes me a little bit squeamish. I mean, most of us are a little bit, as attorneys, are a little bit conservative in nature. We don't like new things, and some of us even like new things lesser than others. This way is allowed, and it's technically correct. I've given this form to some clients, and they've been a little bit squeamish about signing it as well, and we'll go into this a little bit second. There is you look in your packet, there is a form called an AIA or AIA 82 form, okay, and it contains two parts. It has a part A is the transmittal, and then a part B, which is the power of attorney form, okay. With this form, you could file it with the application without having to record the assignment. You have to record in anything where the applicant, where you name an applicant other than the inventors, you have to record the assignment generally up to issuance. You have to have, I think it's issuance, it might be allowance. But you have to record the assignment anyway. So it doesn't make kind of sense. And we're going to go in this in a second. You know, my head is still kind of going to explode from this one. So you got these two forms. You send the Part B form to the client, or you can send them both forms, the Part A and Part B. And we're going to go through an example. Have them execute the Part B form, and that has to be signed by the client. So a company officer, if it's a company like president, you know, vice president, treasurer, secretary, whatever, has to sign that Part B form, which is this form here. They sign it, and then either they can sign this transmittal form, which has what all this does is identify the application. All right? And they can sign that form, or the attorney can sign it. Now what's weird about it is on the power of attorney form, it really makes no mention of this other form. You know, they're kind of separate and floating in air, whereas the general power of attorney, the SB 80 way, at least referred and gave us authority to do it. It was weird, but the Patent Office wants you to do it this way, generally, or is leaning or recommending that you could just send this one form out, the B form out, have it signed, and then for any application, all I do is just change the transmittal sheet for the application. That's where the uneasiness gets with me. It makes me very squeamish to do that. But that's how they set it up. And we're going to go through this in a second, the next slide. So, here's the first form. All it is, and you look at it, Cindy, I'm really shocked you didn't see the Abby Normal reference on that. You don't remember Young Frankenstein?
No.
Oh, okay. Anyway, you'll see all it is just the application number. And if you file the application, say you're filing this with the application, you just leave it all blank. You know, you put the title in there and our docket number. You're not going to know any of the information. And you can just submit that with the application to establish power of attorney along with the Part B form. This form, this transmittal or Part A form, can be signed by the applicant, so such as an officer, a patent attorney, or patent agent, so patent practitioner. All right. Now let's look at the Part B form. This is the power of attorney form. It's very similar to the general power of attorney form. You look at it, you know, it's got, you know, the customer number pointing that, and then, or you can list 10 attorneys, and then here again, just make it that customer number for the correspondence, or here's another correspondence customer number. And then just filling out you could fill out the firm information, but we all use customer numbers here, so it's not a big deal. And then at the bottom, you specify, you'll have to look at the form on this. This is an eye chart. You can either specify the inventor, who's making this, who's signing this form, the legal representative if they're deceased, or assignee, or a person to whom has obligation to assign. And then the last one, person of other interest, which we've talked about before. Maybe there's some sort of ownership interest. It was kind of a handshake agreement. You don't really have an official assignment. They're not going to be signing it. You can still go ahead and file it to protect your rights as an applicant under the AIA rules. So this has to be signed by our client, typically. So again, they want you to recycle this form. So you can have them sign it, even though it doesn't identify any of the application. You can just file this in multiple applications, just changing that transmittal. Again, that makes me very queasy to do that. But the Patent Office, if you go ahead and read the notes on this form, and we called them up and confirmed it with them, and they said, yeah, that's what we want you to do, which is very weird. I mean, just very weird. I don't know how to explain it. Now, when would you use this form, the 82 form? This would be the situation, what Sandy mentioned, where you have maybe multiple inventors, where they're not assigning it over to anyone. That also makes me queasy when you have that, because they usually get into fights when there's money involved. So, but if they want to give us power of attorney, all the inventors, you have each one of them sign, you know, the Part B form, and then you just slap the Part A form on top of it, and we got power of attorney in the case. Okay, that's one way. You can use it to establish, if you don't have an assignment yet from the inventors, you can establish power of attorney right off the bat by submitting these two forms. Have the client sign this, and hopefully in your reporting letter explaining that we can use this for multiple applications, and we're just going to simply change the transmittal form on it. Probably be best with more sophisticated clients that have in-house patent attorneys and they're aware of it. Even them, they're not, I don't think, too excited about it. And so that's the other way you can do it. The only issue you have to worry about is normally you're going to be check the S&E or person whom the inventor is under the obligation to sign box, but you might have situations where they don't have like an employment agreement with them, so it can make, you might have to have them sign two documents in some instances, the two Part B forms. So, and this shows an example. So you might have them. These are probably the two ones that are applied more often in this situation. So normally you probably can be checking the S&E or the S&E box on there. So let's go through an example. All right. You go ahead and prepare a Part B form. Now, in this example, I'm going to just be sending the Part B form to the client. You could send them both Part A and Part B form and have them sign both. All right. That's probably the safer way to do it. But PTO, again, is blessing this version of way to file power of attorney. So you prepare the Part B form. You send it to the client. They go ahead and sign it and send it back to you. And then what you can do is, for any application you file, you just prepare the Part A form with the application number, or if you're filing it with the application basically blank and just the title and our docket number on there. And you go ahead and prepare the Part A form, and you submit those to the patent office, and you got power of attorney. Kind of weird. All right. Let's do another example. This is probably the more common example. You might want to use this form where you have two separate inventors, Andy and Betty in this example. You go ahead and prepare a Part A or Part B form, 82 Part B form. Man, I just say this a lot. Part B form for Betty as well as Andy. And then you go ahead and send them to the individual inventors and then have them sign it. And then they send it back to us, and then you submit both of those forms with the Part A form as shown here. So you fill out the information and file it with the application. That makes sense? I know it's a little squeamish, it's a little weird, but just want to explain it to you. So there's two ways. You can do the old standard way, or you can do this way. So. Here's just showing another example of how the power of attorney form works. So your Part A form and your Part B form, and then sometime you're going to have to record the assignment separately. But with this way, you don't need to have the assignment recorded right away. So that's a nice thing about it. Okay, let's talk about continuing applications. They've explicitly now allowed in the rules for continuing and divisional applications. You can take the power of attorney from the parent one, copy it, slap it, and file it, and the next one you got power of attorney. So you don't need to go through all this rigmarole. So that's a nice thing about it. There are exceptions. If you have like independent inventors and they all gave you power of attorney and then you change inventorship, you can't use that same old power of attorney. You got to have them re-execute a new power of attorney because you got different inventors, different applicants technically. Or again, if you add or
I hope you found this presentation to be helpful. If you have any questions or comments about this topic or any other patent-related topics, please feel free to call me at 317-713-4954 or send me an email at cschmall@uspatent.com.